5 seconds to go. Start. The victim was got medically examined from the Ames hospital. The accused was arrested in this case and his potency test was got conducted, wherein it was opined by the doctor that the accused was capable of performing sexual intercourse. The exhibits were seized by the police and sent to the FSL Rohini for analysis. The statements of the witnesses were recorded, and after completion of the investigation, the charge sheet was prepared against the accused for the commission of the offences punishable under sections 376 and 506 of the Indian Penal Code and sections of the Protection of Children from Sexual Offences Act 2012 and put up before the court. Charge for the commission of the offences punishable under sections 376 and 506 of the Indian Penal Code and sections of the Protection of Children from Sexual Offences Act 2012 was framed against the accused, to which the accused pleaded not guilty and claimed trial, and the case was proceeded for prosecution evidence. In order to bring home the guilt of the accused, the prosecution examined 9 witnesses in all. The incriminating evidence and circumstances were put to the accused before recording his statement under section 313 CRPC, wherein he claimed to have been falsely implicated and chose not to lead any evidence in his defense. After appreciating and considering the rival contentions of the parties and scrutinizing the evidence, the learned trial court held the accused guilty and convicted him for the charged offences. Arguments addressed on behalf of appellant. Mr. Krishan Kumar, learned counsel for the appellant, opened his arguments by submitting that the impugned judgment dated 27th July 2018 is based on conjectures and surmises, and the same is against the facts and settled proposition of law, and that the learned trial court has ignored and omitted the material evidence and has disregarded the cogent evidence in favour of the appellant. Learned counsel for the appellant further contended that the learned trial court had erred in holding the appellant guilty for the charged offences, and the judgment rendered by the learned trial court is perverse, that the evidence which had surfaced during the course of the trial was not properly appreciated, and a proper appreciation of the facts and circumstances would have definitely resulted in the acquittal of appellant for the charged offences, that the testimony of the prosecutrix is totally unreliable, as well as there are material contradictions and concealments in her testimony recorded under section 164 CRPC and in her deposition before court, that the evidence of a child witness has to be evaluated more carefully with greater circumspection, and the same can only be relied upon if there are no embellishment or improvement therein, that there are severe contradictions and inconsistencies in the testimonies of other material witnesses, that the case of the prosecution is neither supported by medical evidence nor by scientific evidence, that the solitary testimony of the victim in a case of rape is sufficient to convict the accused, subject to condition that the same inspires confidence of the court, but in instant case the sole testimony of the victim fails to inspire confidence and is unworthy of acceptance. Learned counsel for the appellant further contended that the learned trial court erred in convicting the appellant accused under the POCSO Act, as the Act came into existence on 14th November 2012, and during the alleged period when the offence was committed, the POCSO Act was not even enforced. He further added that the offence was committed during a continuous period from 2010 to 2012, wherein the prosecutrix had not disclosed the exact date and time with regard to the sexual assault committed on her in the month of November-December 2012. It was further submitted that, in view of the aforesaid circumstances, the conviction of the appellant accused under the POCSO Act was not sustainable in law, and the punishment imposed on the appellant accused needs to be reduced from life imprisonment to 10 years. Counsel for the appellant lastly urged that the trial court had not properly appreciated the facts and circumstances of the case. Hence, the impugned judgment was liable to be set aside. Arguments addressed on behalf of State. Ms. Asha Tiwari, learned APP for State, on the other hand, strongly refuted the submissions made by the counsel for the appellant and submitted that the learned trial court, after proper appreciation of the evidence adduced by the prosecution, has rightly convicted the appellant for the charged offences, and the appeal filed by the appellant accused is liable to be dismissed. Learned APP for the State further submitted that the learned trial court has appreciated the testimony of the prosecutrix in its right perspective, and relying on the well settled proposition of law that the sole testimony of the victim of a sexual offence is sufficient to base conviction of the accused. She further submitted that the version of the victim recorded under section 164 of the CRPC and the testimony of the prosecutrix before court was consistent and unimpeachable. She further submitted that in such cases of heinous crimes, normal discrepancies are bound to occur in the deposition of a child witness due to normal errors of observation, namely error of memory due to mental disposition at the time of the incident. To substantiate her arguments, learned APP for State relied upon the case of State of Punjab versus Gurmeet Singh and others, reported in 1996 to SCC 384. State Government of NCT of Delhi versus Pankaj Chaudhary, reported in AIR 2018 SC 5412. Stop.